So I'd like to welcome you to our presentation, to all of you. We've got lots of participants from all over the United States. Today's presentation is on ADA compliance for educators. Our primary audience today is educators and administrators from among, as I said earlier, our current clients all over the United States, but we also have lots of newcomers from outside of our clientele, and we welcome you warmly. My name is Adam Karish, and I am the Chief Executive Officer at Karish & Associates. Karish has its headquarters in the Philadelphia area, Westchester, Pennsylvania, and we conduct hundreds of remote accessibility service sessions every week. We have been serving the community for 40 years, and we have clients in all 50 states in varying industries and 24/7 in-house tech support. So really our team is made up of experts in accessibility services and remote solutions for ADA accommodations, and in particular for the deaf, the hard of hearing, and the visually impaired communities. So I am joined today by Michael Torsha, Esquire, and he is an experienced attorney and presenter. Michael, why don't you take this opportunity and introduce yourself?
Hello, everyone. As Adam said, I'm Mike Torsha. I'm from the law firm of Seminoff, Ormsby, Greenberg, and Torsha. We are sitting here in a suburb of Philadelphia over on the East Coast. I've been a labor and employment attorney for nearly 30 years, and along with our group at the firm, we represent mostly businesses and give consulting and advice, particularly about the American with Disabilities Act, the Family Medical Leave Act, and associated statutes. So very happy to be with you all this morning.
Excellent. So briefly about today's presentation. So with Mike's help, our presentation is going to highlight, on the one hand, legal liabilities by using case study results from the ADA law, specifically focused on education, with a special emphasis on the deaf, the hard of hearing, and the visually impaired communities. We'll also be presenting how to navigate avoiding these potential legal liabilities with practical solutions. The event, as you might know, is part of a series, and the series is called ADA Compliance in Practice. And the series focuses on the relevance of ADA law for the deaf, the hard of hearing, and the visually impaired. Each session will showcase the legal and the practical implications, just like the one today, of individual ADA law titles. Now, today's meeting will be covering Title III in particular, as you know from our promo that you received and when you registered. Our next pre-session, which is just so happens it's going to be taking place tomorrow at the same time, is focused on Title I and the applications of ADA compliance in employment law. So if you'd like to register for that or know somebody who would, please send me an email or go to our website and our blog, and you can find a posting about that there and register. We will end today's presentation with a Q&A session, which will go about 15 minutes, and we invite you to participate in that as well. If you have any questions during the presentation, please feel free to ask them in the chat box that you see at the bottom or the side of your screen, and we'll do our best to get to them. If we can't get to them during the presentation for whatever reason, we will definitely get to them in the Q&A session afterwards. So as you've noticed, we'll also be muting your mics to avoid any distraction to other participants or attendees, and but you can use the chat function at all times. So Mike, why don't you take it from here?
All right. So I will start off by talking a little bit about the ADA. Some of you may already be familiar with the basics of the ADA. Some of you may not, but it doesn't hurt for a little refresher. So let's just start at the beginning. The American with Disabilities Act is a federal law, not state, and that's important, that was passed in 1990. And in 2008, there was a very important amendment to the ADA. Some people call it the ADA AA, which is, I think, a little cumbersome, but it was passed in 2008, and it was important because it expanded the scope of what was considered a disability. So it made it very clear that disabilities really cover a wide scope of health issues. The ADA itself has many provisions. There are 5 primary sections. And right in the center of your screen, we're going to be talking about Title III, as Adam said, public accommodations. As Adam also mentioned, tomorrow we're going to be talking about the employment provisions, those ADA regulations that apply to employees particularly, but today applies to everyone, members of the public especially. So under Title III of the ADA, again called public accommodations, very common sense, I think, the ADA Title III, as the entire ADA itself, prohibits disability discrimination and requires access to places of public accommodation. So those people who have a disability, as that's defined, have to have access, equal access, to places of public accommodation. Well, what's a place of public accommodation? And there are examples here on your screen. By the way, one of the reasons we're recording this today and we'll be providing it to you is because there are some slides here with lots of words. So we don't expect you to to take notes on all of this verbiage here. So never fear, it'll be available to you later. So a place of public accommodation includes all of these things you see in the center of your screen: restaurants, movie theaters, schools, recreation facilities, healthcare facilities, commercial buildings, factories, warehouses, etc. So almost any place you can think of where the public has access to. This, of course, includes colleges and universities and schools, and very importantly, which we'll talk more in this session, communications from those places. So whatever colleges and universities send out there to the world, whether it's on their website or whether it's a seminar or a conference, including internet content and school announcements. One of the questions people ask all the time, so we figured let's just get right into the negative part of this, is what are the penalties? So we'll talk about complying with the ADA, but you should know, well, what happens if you don't? So if you don't comply with this particular title of the ADA, there could be an investigation by the government, by the Department of Labor, and what they call a compliance review. That's just a fancy way of saying that you've done something wrong and they're going to make you do it right. There could be private lawsuits brought by individuals who are disabled and don't have access to the public accommodation. And there could be lawsuits brought by the Attorney General. Again, that's the Attorney General of the United States. There are many, many remedies that are available to either the government or people who file a lawsuit. The remedies include those things on your lower left, the bullet points there. There could be injunctive relief. Injunctive relief means that a court is going to force you to do something or to stop doing something. A court could force the entity, the school, or the business to provide an auxiliary aid or service. You notice how that's bolded? We're going to talk about that in just a minute. Or modify a policy or modify a procedure or to make the facilities available. Those are all things to fix the problem. They also have the remedy of money, of a fine or a penalty, right? You may have to pay the person who does not have access. There could be civil penalties, and you see some of the numbers there that they can add up, $55,000, up to $55,000 for the first violation, et cetera. Punitive damages are what scares lots of schools and employers. Punitive damages are punishment damages. That means that the court decides or the jury decides that it's not enough just to make you do the right thing, that you need to be taught a lesson. And this is normally in play when a school or a business should know better. So maybe there was a previous investigation, maybe they've been sued before, but they still didn't fix it. And we'll see in a minute how the element of good faith of trying to do the right thing really matters. And then there are attorney's fees. You may have to pay not only your own attorney, but you may have to pay the other side's attorney, which can really add up. So as I mentioned just a second ago, courts take into consideration good faith efforts. That means that you may have violated a regulation under the ADA, but if you made a good faith effort, if you tried to comply, maybe you didn't do it correctly, but if you tried to comply, that counts. That matters in terms of what sort of damages might be assessed against your school or your business. And one of the things that they take into consideration is the second point here, whether the entity, the school or business, could have reasonably anticipated the need for an appropriate auxiliary aid. In other words, did you know that someone needed it or a group of people needed it? Or could you or should you have reasonably anticipated that that was necessary? If the court decides or the jury decides, yeah, you should have realized it, come on, how did you not know? But you still didn't provide it, then the chances are the damages will be much greater if there are damages. All right, so let's talk about this term auxiliary aids and services. What does that mean that a business, a school needs to provide auxiliary aids and services? Well, here's the basic rule. Again, I think pretty common sense. No individual with a disability can be excluded or denied services or segregated or treated differently than other individuals because there are no auxiliary aids and services. Frankly, I think all of that language can go out the window, and all you need to know is that little middle phrase right there that says treated differently. No individual with a disability can be treated differently. Now, there's an exception to this. The exception is that the school or the business does not have to accommodate someone with a disability if providing that accommodation would fundamentally alter the nature of the business. And you see the language here, would fundamentally alter the nature of the goods, services, privileges, etc., or it would result in an undue burden. And as you might imagine, the exception is litigated very often. Businesses often say, we didn't provide the accommodation, but we were not required to because it would have fundamentally altered our business, or it would have created an undue burden. There are many, many cases out there that talk about what is an undue burden. But basically, a public accommodation needs to provide the auxiliary aid. And the type of auxiliary aid will change. It will vary according to the method of communication used by an individual. It'll vary by the nature, length, and complexity of the communication, and also the context in which the communication is taking place. Again, a fancy way of saying it depends. What skills does the person have to communicate? What is their disability? When and to whom are they communicating? That will decide. Wow, lots of words on this slide. All right. Not going to read this whole thing, as we said, but we want to, this is cut and pasted from the regulations, from the ADA regulations. And this is really at the heart of the matter of what we wanted to stress for today. What is an auxiliary aid or service that your organization needs to consider? And you'll see that this is a pretty comprehensive list. It's not meant to be every single thing, by the way, that could be considered an auxiliary aid or service. You'll notice right at the top of the screen, it says the term auxiliary aids and services includes. It doesn't say that this is the exclusive list. So it includes all of these things. And it's meant to be fluid. It's meant to change over time. And in fact, that's the point, that you really should be providing the most appropriate auxiliary aid and service, which includes, and you'll see the bolded words in the center here, open and closed captioning, including real-time captioning. And then down in number 2, for those who are visually impaired, braille materials and displays. Some of the things on this list here are outdated and are not really used anymore. They don't exactly update the regulations to the ADA, every month. So the message here is that nothing in the text of the ADA specifically requires the use of closed captioning or visible text or subtitling. And Adam's going to talk about these particular services in detail in just a minute, because the regulation allows flexibility. But many of the alternatives here have been replaced or disfavored. So really you have to think to yourself, what is what is used currently, what is cutting edge, what is the most efficient, and what's the most appropriate in this situation. So on that point, let me turn it over to Adam to talk about the details of some of these accommodations and these auxiliary aids, so you get a little better sense of what people are using out there.
Excellent. Thanks a lot, Mike. Right. So public accommodations and education, online learning. So Title III requirements are equally as relevant to on-site education settings as they are to online learning. As we'll discuss in the case studies that are coming up, requirements include, pre-recorded coursework, live classes, as well as school content that's showcased online, whether that's audio or video content. It's on your school domains or it's on third-party domains and platforms. It has to take accommodations into consideration. What you have to remember as a school administrator or as an educator is that upon a specific request by an individual who is unable to access specific content, your school or your organization is obliged to provide accommodations for any new video or audio content created or produced by the school and posted on official channels. So we're talking about the school's website, your official YouTube channels, your Vimeo, wherever it is you are posting your content. And this is relevant for schools, this is relevant for their museums, their libraries, and in some cases, as we'll see, also their legacy content. We'll talk about that in the case studies. So one of the settlements that we'll be delving into a little bit later is it's specified that the schools must provide what's called industry standard live captioning for all the live events, including their live streamed events. Now, that goes for videos and audio, as I said above, which is live streamed. Now, that would mean, for example, ceremonies, all types of commencements, presidential installations, and other events that we would consider high interest. So in the case of MIT and Harvard, which is one of the case studies, their settlement, in their settlement, they're basically given 5 business days to provide any such content after receiving a request. That's pretty stringent, and it might raise some question marks for some of you here today, but don't worry about it. We'll get into those questions and the specifics about it in a few moments. In terms of permissible accommodations, which is, I guess, the next one. Yes, thank you. So in terms of permissible accommodations, Mike touched on this a little bit, that the ADA law stipulates a specific list of auxiliary aids and services, otherwise referred to as accommodations. And the federal regulation, it proposes kind of a long list of specific accommodations, but that list includes, in some cases, arcane, outdated recommendations for most, for example, telephone handset amplifiers, or simply exchanging of written notes. That's a quote. And several, though, are really mainstream. They're very popular, and they're used commonly at universities, colleges, high schools throughout the United States. So in this part of our presentation today, what we decided to do was focus on outlining 4 of the most universal solutions, the most common services that are provided on-site as well as remotely for distance learning scenarios. So let me emphasize that based on our experience with schools, as I said, in all 50 states, all these examples, with the exception of one, are equally relevant solutions for on-site teaching as well as for distance learning scenarios. So we'll be covering 4 kind of baskets of accommodations. The first is real-time captioning. We'll be talking about a few different types of real-time captioning. The second is transcription and note-taking. That is mostly for pre-recorded audio files. The third will be qualified interpreters, on-site or remote. And the fourth will be dedicated services for the visually impaired. So the first batch here is real-time captioning. Now, real-time captioning is otherwise referred to as CART captioning. CART captioning is perhaps the most ubiquitous and inclusive accommodation for the deaf and the hard of hearing communities. And it's great for live events like we have today, as well as online learning, classroom teaching, commencement ceremonies, et cetera, et cetera. We do all of those, and it's very applicable there. CART is an acronym, and it stands for Communication Access Real-Time Translation. Communication Access Real-Time Translation. And it is the process of turning the spoken word into captioned text, as you can see at the bottom of your screen today. CART is provided in real time for individuals or for groups of any size in any setting. It's very versatile. And the speaker's audio is transmitted from the microphone to our certified captioner, and it's displayed as text on a large screen monitor or a screen or your laptop computer with 98% accuracy. And all of this happens within 2 to 4 seconds, as you're seeing today. So within real-time captioning, within this category, we've also put internet captioning and live streaming for events, which is slightly different from a technical perspective, but for you as the end user or the viewer, very similar. It's for live streamed events on the internet, as well as uploaded videos that stream on YouTube, for example, or Vimeo. A service that you might be familiar with, maybe not, is called meaning for meaning captioning. Now this, we put it in the same category, but it's really quite different. It is real-time conversion of speech into summarized text for individual viewers. Now the service is most often provided for educational settings, or for meetings, like we do a lot of municipal meetings, board meetings, etc., where a summarized version of what's happening is more relevant, appointments, etc. So you may have heard of Typewell or cPrint. They refer more to the software that Meaning and Meaning is provided in. In terms of the end user's experience, your experience, they are identical to one another. So Typewell, cPrint is all meaning for meaning captioning. Also, finally, in this basket is what we call broadcast captioning, which requires a specialized type of software and exceptional skill on behalf of the captioner. We most often use broadcast captioning for TV programs, as well as live, very large-scale public events, or simply if a client specifically requests a broadcast captioner. The next package or bundle that we're talking about here is for pre-recorded audio files. And this is what we've titled transcription and note-taking. So in the transcription, note-taking, and offline captioning package, we've thrown transcription, which is basically the creation of a 100% accurate verbatim transcript from a pre-recorded audio or video file. Note-taking, on the other hand, is the process of taking a verbatim or summarized, taking the verbatim and creating summarized notes from a lecture or a meeting or a presentation and turning them into like a readable format for you. And that can either be a summarized version or it can be a verbatim version. It really depends on the needs of your student or your group, whoever it is the end user is going to be. When it comes to note-taking, there are really myriad formats, levels of accuracy, and turnaround time. It really depends on the end user again and what the needs are. In this basket, we have offline or closed captioning and open captioning. Offline or closed captioning is basically closed captions for pre-recorded material, and it's used for broadcast or internet videos. The captioning for these can be turned off, hence the name offline captioning. Open captioning, on the other hand, is very similar to closed captioning. The difference is that the captions cannot be turned off, and these are often referred to as subtitles. In the next basket, we are talking about qualified interpreters. This is relevant for on-site or for remote scenarios, like today. American Sign Language, otherwise referred to as ASL, can be provided on-site or remote. in a classroom, business meetings, at an event, etc. You only want to permit trained and certified ASL interpreters to cover classes or meetings to ensure really the best real-time service available. Very, very important. We'll be talking about certification a little bit later. Another service inside of the qualified interpreters basket is tactile ASL or tactile signing. Tactile signing refers to signing using touch, and it is a common means of communication used by people with deaf blindness. It's also a basis, it's kind of based on sign language or some other system of manual communication. Interestingly enough, before the COVID-19 restrictions hit, our team participated in a placement process to help a school student who was deafblind in a middle school here in Pennsylvania. And she required, and her school required, an affordable, full-time tactile ASL interpreter in the school with her at class every day. And happily, we were able to send out a few very strong candidates almost instantaneously for to help that little girl out. So that was very rewarding for me and for our team. So the reason I mention that is because it's very important that you keep in mind that the accommodations that you select, they must be attentive to your specific student's needs. So some people are, for example, late deafened. They are not born deaf. They don't know ASL, and so captioning is really a better option for them. Those fluent in ASL, on the other hand, take great pride in their unique language, in their culture, and many of them don't consider captions really an authentic alternative to ASL interpreting. So in some cases, as in today's case, it really is wise to use both solutions, and that is the best option for a large group of participants. In this next slide, we'll be talking about not case studies yet. If you could go back to the previous slide, that would be great. Yeah, dedicated services for the visually impaired. So very briefly, we'll be talking briefly about two services here, or two solutions, accommodations for the visually impaired. One is what we refer to as real-time Braille cart. And what we call Braille cart is provided by a certified expert cart captioner who then connects to the individual student's Braille reader. And that allows the end user to interact in real time in really any environment. It's worth noting that real-time Braille cart is not a fully remote service. That might be relevant to some of you in today's world. The second is audio description, and it's an interesting service for the visually impaired, which is basically the process of narrating all the actions and events that are taking place in a video or during a live event. Until COVID-19 restrictions struck, we were providing this service regularly for training seminars, for plays and theatrical productions, and currently it's primarily ordered for pre-recorded materials rather than for live events. But hopefully that'll be changing back again soon. I think, Mike, I think this is a good time for you to take over with introducing the case studies.
All right, thank you, Adam. So we have a couple of case studies for you today to bring some of this theory into practical terms and how some of these things kind of shake out in the legal world. The first is actually a combination of two lawsuits. The National Association of the Deaf, NAD, brought lawsuits against Harvard and MIT pretty close to the same time, around the same time. These were class action lawsuits. So these were brought on behalf of not necessarily just a single person, but a class of people. And of course, in this case, the class of people were deaf individuals. They brought the cases in Massachusetts federal court. They were actually combined by the judge but they were treated somewhat differently when it came to the settlements. But the judge had conferences with both of these cases together because they were so similar. So the plaintiffs, in this case, the NAD, argued that the schools failed to provide equal access for deaf and hearing impaired individuals, and much of the school's audio and audiovisual content was not made available to the public. And the plaintiffs argued that the colleges violated the ADA it was available to the public. And they said that the colleges violated the ADA because of the lack of quality and the comprehensive video captioning in what they call the Massive Open Online Courses, MOOC, that was made available to the public. So essentially, putting it in the language of what we talked about a few minutes ago with the regulations, the plaintiffs argued that disabled individuals were not being treated the same as non-disabled individuals when it came to the content that was going out to the public. Now, the defendants, Harvard and MIT, they initially argued that their websites and the online content were not places of public accommodation. They said that the online content was not they focused on the language of the regulations. They said that the online content was not an aid or a benefit or a service requiring equal access. So essentially they said, well,
Mike, sorry, hold on a second.
Oh, sure.
We're switching interpreters, so I just wanted to make sure Charles knew.
Yes, thank you.
Okay, great, thanks.
No problem at all. I'll just start on this one more time. So the defendants argued that the websites and the content that they were putting out to the public were not, quote, places of public accommodation. They were saying that the content that they put out there, and to quote the language of the regulations, was not an aid or a benefit or a service that required equal access. In this case, they defined caption and captioning to mean, again, lots of words on this slide here, but they define it to mean this definition of putting it out there to the public. But very importantly is this bolded language you see towards the bottom of the screen, that caption or captioning meant to put it out there to the public in a manner consistent with industry standards. So this goes back to what I mentioned a few minutes ago and what Adam mentioned. It's not that you can put it out in any way. It has to be put out there with a certain quality and a certain timing and in a manner consistent with the industry standard. Now, of course, that's a moving target, right? What's an industry standard today is not what it was years ago, or years ago, doesn't suffice for what it is today. So that's a very important point of these cases. So as often happens in these matters, these cases resolved, they settled, they did not go to a jury trial. The Harvard case settled in November 2019 with a consent decree. A consent decree is just a settlement agreement. And for the Harvard case, there were lots of fees that were paid. They agreed to pay, I think it was $1.5 million in attorney's fees for the plaintiff. And they agreed that they would cover their online interactive courses, including student online courses, and they would make them readily available in a quality consistent with industry standards. They also agreed to make these communications available upon request. So if someone had a request for a back video or a back communication that was not already formatted, that they would do that. But the point is, they ended up doing what the ADA requires them to do, and they ended up paying their own attorneys, and they ended up paying the plaintiff's attorneys. MIT had a very similar settlement. I think they only paid $1 million, only $1 million rather than 1.5, but also agreed to provide the online content. Their settlement did not include student classes and courses because they were already doing that. So basically, both schools agreed to provide the content, to pay the money, and and to comply going forward. So, Adam, did you want to talk a little bit more about the settlements and how the impact of those? You might be muted, I think.
Sorry, I clicked it a couple times and very briefly, so as you said, Mike, as of February 2020, the NAD versus Harvard and NAD versus MIT, the lawsuits, each of them got settled through what you call consent decrees. And I think I'm going to extract a couple of interesting facts, I think, from the practitioner's side from these two cases. So according to the NAD, and I happen to agree with this, both settlements represent, and this is a quote by the NAD, the most comprehensive set of online accessibility requirements in higher education, and they also provide a new model for ensuring worldwide online and digital accessibility in academia and business for people who are deaf and hard of hearing. Now, that is the truth. I mean, these cases have set a new gold standard for educators as well as for the business community. And I'm finding that it's not commonly known outside of our webinars and maybe specialized attorneys or activists. So we thought you should know. And although the NAD versus the Harvard settlement can't be really treated as a specific precedent for other cases, they are a high-profile case, or two cases, in fact, that do give us really useful behind-the-curtain looks at sample situations that could be similar to ones that your schools could find themselves in. So in both these cases, it took about 4 years of litigation to reach a settlement. But the silver lining in all that litigation is that it really strengthened Harvard's new, what they call digital accessibility policy, which is, as I said, a gold standard for other schools, and has established a set of captioning guidelines so that Harvard University could continue to improve accessibility for its online resources and for those who are deaf and hard of hearing. But it's worth noting that Harvard, and I think, Mike, that you did touch on this, that Harvard had already been captioning much of their online content prior to the litigation proceedings. So an important component of the settlement was that it guaranteed that the university had to provide, and again this term, high quality captioning services for online content from that point on. So I wanted to take this moment to take a closer look at this particular stipulation of the settlements. High quality industry standard captioning. What does that mean? I think there's a lot of relevance here to the people attending this webinar. So a school or their selected agency needs to put years of consistent work into maintaining industry standards by ensuring accuracy on the one hand and certifications on the other. You can do this by demanding that your captioners and your ASL interpreters, that they have the appropriate certifications. You can do this by applying the proper, internal vetting procedures. You can do this by matching a captioner's experience to a particular deaf student's specific needs. I mean, there are a number of different ways to ensure the accuracy and the standards. This case study refers specifically to offline materials, so pre-recorded content. And for pre-recorded materials, the expectation is nothing less than 100% accuracy. Assuming you need, you need, like most clients do, an SRT file, a record of the event. For publishing purposes, you'll also need a professional speaker diarization, as well as a timed-in captioning. So it's worth noting that these same standards apply for captioning as well as for American Sign Language interpreting. Now, in real-time scenarios, the definition of high-quality industry standard captioning refers to an accuracy level that is, of course, not 100%, but really nothing less than 97% accuracy in real time. So that's for live events like today's event. As pertains to certifications, in order to provide high-quality industry standard service, captioners require years of training, specialized software and hardware, and usually national and often additionally state certifications. So for exactly these reasons, artificial intelligence solutions that you might be getting spammed with are, and they're all asynchronous at this point in time, they are simply not, they don't meet industry standards for real-time scenarios like today's event. So that's just a couple of notes there, like before you move on to the next case study.
Great. So we have a second case study for you, but let me just make a comment off the slides for a minute. This is a bonus case study. There was a case that was relatively recently filed, December 18th of 2020. So it's just a couple of months old. It was filed in federal court in the Eastern District of New York, and it's called Kane with a K, K-A-N-E, versus Zoom Video. That's right, Zoom, like what we're on, the platform. And very interesting case. It's a class action brought by a disabled individual, someone who is hearing impaired. And the case says, or the case alleges, that Zoom is a public accommodation. You're putting it out there to the public. And Zoom does provide captioning for its service, but they charge a fee. They have a surcharge. And the lawsuit says, no, you need to provide equal access to hearing impaired people who are participating in your service without charging an extra fee. Thank you for providing these auxiliary aids and complying with the ADA. And I mean that sort of sarcastically because, what's the alternative? They wouldn't provide an ADA accommodation. They have to do it, the company that is. But you can't charge an extra fee. You can't have a surcharge. So the case is so new that the company has not even responded to the complaint yet. I checked this morning on the docket, nothing new as of 11 o'clock this morning. So we're going to keep our eye on it. Very interesting case, but you're going to see more and more cases like this for against the Zoom Video. All right, so now on to our official second case study. So this is a very different case study than the first one. The first one was a double case brought by a national organization, NAD, against high-profile universities, Harvard and MIT, and they were class action lawsuits. Hundreds, maybe thousands of people involved as potential plaintiffs for that lawsuit. This is the opposite. This is a single individual, not on behalf of a class, bringing a lawsuit against Creighton University. And in this case, Mr. Argeni, or I should say Dr. Argeni, was attending medical school at Creighton University. And he did not know American Sign Language, but relied on lip reading and cued speech, using hand signals to represent sounds. He had received a cochlear implant before starting medical school. And for the first 2 years of his medical training, he had been provided with cart services and an interpreter, a speech interpreter, that he paid for himself. But then the school, and I'm really paraphrasing and making simple here, the school basically said, we don't want you to do that anymore in your third and fourth year. We believe that you will have difficulty communicating with patients out in the real world. So we want you to find a more direct and less cumbersome way of communicating with patients. Dr. Argeni, I guess he was Mr. Argeni at the time, was so concerned that he would not succeed that he took time off and he sued the school. They had a trial. They could not resolve it. They had a trial, and the jury determined, let me see if you're here. Yeah, the jury ruled for Mr. Argeni and found that there was discrimination on part of the school. They found that there was no undue burden by the university to continue to provide the cart services and the interpreter, but they awarded no damages. They did not award any money to Argeni. So the plaintiff, Argeni, filed a motion that went to the judge and said to the judge, you know, hey, thank you for deciding that there was discrimination, but I want some money here. So the judge ruled in favor of Argeni again and decided that the college needed to provide auxiliary aids in all settings, and awarded $449,000 in attorney's fees and $30,000 in costs, which theoretically makes Argeni whole, so he doesn't come out behind, but did not award any other monetary damages. Remember, a little while ago, I mentioned these punitive damages, this concept of punishment against a school or a business for, you know, knowingly doing the wrong thing, for bad faith. But the judge decided that the school did not act in bad faith. The school thought they were doing the right thing. They thought they were helping Argeni. They did not intend to discriminate. I mean, after all, the school admitted him to this medical school in the first place, right? Knowing that he had a disability. So there was no evidence of bad faith, and no additional money was awarded to Argeni. And again, a great example of how good faith made a difference in this lawsuit. Adam, comments about this one?
Yes, definitely. I was just reading interesting comments from our attendees as well. So yeah, this is a second, fascinating case study, and very telling. On its face, it would seem that the student, the doctor, simply required, cart captioning, right? But as we delve deeper into it, we see that the student's needs are more subtle and unique, and the school's requirements are really more demanding. And the case study shows, once again, that accessibility accommodations, especially in an educational setting, don't offer, a one-size-fits-all solution. Oftentimes, schools, they don't know exactly what they need. And they are looking for experience-based guidance, and that I think is really relevant. And it brings me to our next and almost final slide about choosing your agency. So if you could just switch over, there you go. Thank you. So in terms of choosing your agency to assist you with any of these accommodations, I have been touching throughout the presentation, as has Mike, on different accommodations. We went through the section about, with 4 packages or batches of different accommodations for different types of situations, all relevant to the deaf, the hard of hearing, and the visually impaired communities that you work with every single day. Now, Carish provides all of these services to schools like yours throughout the country every day, and we have for decades. So what I'd like you to leave this webinar with is at least one thought, and that is to remember that when it comes to ADA compliance accommodations, don't wing it. Please just reach out to us for advice, for guidance. There is no need to be apprehensive about moving your students, your student-teacher interactions remote if you are prepared. So it can even be, we found in certain situations, really an improvement if you do have the right instruction and the right support. And the next point that I wanted to touch on here is a little bit of an adjustment. So typically in webinars like this, I'll try to implement a component about even more practical considerations to remember while you're implementing your accommodations on site or remotely. But what we're going to do is we're going to move that offline. We usually look at 3 things: setup and testing, tech support, and security issues. But what I'm going to do is, for anybody who's really interested in that kind of thing, please contact me and we'll be happy to set up a demo for you and your team with a free demo, of course, but a demo to walk you through the setup and testing, the tech support, and the security items, if that specifically interests you. One thing I did want to mention here, though, in place of that, is we interact regularly with educators from universities and school districts all across the U.S., as well as with parents of the deaf and the hard of hearing and of blind children and youth. And one thing we hear from many of them, especially after these webinars, is, Adam, that was very informative. Thank you, but I have zero power to make change. Especially with anything that costs money. Adam, I can tell you all about how our district's, our district works and its problems and our school's problems, but if it requires any sort of money, I have no way of really fixing anything. From the same from parents with their children in schools. You may feel similarly, and we don't want you to end today's seminar feeling helpless or powerless, despite the fact that you've been given these tools to advocate for improvements. And we understand that not all of you attending the webinar are decision makers, but encountering decision makers is a regular event for me and our team, and we would like to help you as well. So we'd like to offer you, a free kind of consultation, private consultation for you and your team offline. For any of those who want to sign up for a session like that, just go to the chat box and I will give you a link now where you can set up, schedule an appointment with us, with me and somebody from our team. And during that consultation, we can walk you through, you and your team through a demo of a solution that maybe solves a problem that is relevant to you specifically, as well as the security components that I talked about earlier. One also final note before we move on to our last slide is that we'll also be offering all the people participating on today's webinar, or in today's webinar, we'll be offering everyone a 1 hour of free service, whatever that service is, with your first order of 2 or more hours of service from Karish. We'd like to get to know you, we'd like to work together, and we'd like to help you. So please contact us to take advantage of that, and just reference the webinar, and we'll be happy to help you out. Oh, and the link. I told you all that I would post that link so you could schedule a meeting. And so that's it. It should be in the chat, and I hope you all see it. And if that is for whatever reason difficult, then just send me an email. That works as well. Right. So there it is. This is really our Q&A session. We're right on time. We'll be sending you, I guess before I get to the survey and all that, why don't we open it up for questions? If anybody has any, please send them through to us on our chat, and we'll be happy to get to those.
I saw one question, Adam, about checking the docket earlier in the chat. The question is, checking the docket is, I suppose I should find that again in the chat, but I'm doing it by memory. Is there a place where you can look for all of the cases that are related to higher education and these types of matters, these types of legal matters? The quick answer is no. There's not a central place to look. When I was talking about checking the docket, there is a service called PACER, P-A-C-E-R. And that is a service provided by the federal court system to check any federal case in regular district court or bankruptcy court that's filed anywhere in the country. It's a very, very comprehensive service and very useful. You can look at the complaint and the answer and motions and things like that, even most legal briefs that are filed. So the problem with that is it's not divided by entity. You can't search, for example, all schools. You can search for a particular school, but not all educational facilities. But you can search by subject matter. So you can search for ADA cases, but you'd have to weed through, many, many cases, of course, to look for educational institutions. And then on a state level, I haven't talked about this too much. I'll just mention it briefly. We've been talking about the ADA, which is a federal statute. Many states have their own version of disability discrimination and public accommodation law. And they are very, very different from each other. The states have, wide variety of regulations. And each state has their own system of finding cases on the docket, and some are very good and some are not so good. So when we talk about complying with disability laws, we definitely look at federal law and regulations, but very often have to look at state law as well, which may or may not be even more broad than the ADA. It's possible.
Thank you. We have two questions here. So one was kind of answered in the chat, but I'll just repeat that for everyone. So the question was, how can we access this recorded webinar in the future? And the answer is that we'll be following up with you via email. We'll be connecting with you and trying to keep our communication alive with you. And one of the things we'll be doing is sending you a recording of this webinar that you'll be able to access at any time. So I hope that's helpful. Another question that we have is from Stephanie, and she says, currently in some Zoom accounts, they offer Otter AI captions. And do you believe this is an adequate solution for general access, but if consumers request card services, to then provide the captioner? So again, I can't tell you, I can't tell you. The law doesn't stipulate, and correct me if I'm wrong here, Michael, but the law does not stipulate that that is an appropriate or inappropriate solution. What I can tell you is that if your message matters, so if the content of your conversation or your board meeting or the content of the event that's taking place, if it matters, if in fact every word matters, and you want to avoid gibberish being communicated instead of accurate terminology, accurate proper names, and you don't want sentences omitted, and then Otter AI is just not going to cut it. The other thing is if you have multiple speakers like you do today. So even if you have two speakers, you'll find that automated solutions simply don't cut it. So you'll get jumbled text, you'll get omissions, and again, I'm not talking down about Otter AI or these other services. They're great. They're amazing. I mean, they didn't exist just a few years ago. It's amazing what the human capacity to come up with solutions. So they're great for very casual situations. We don't really work in the realm of casual situations. We're working in professional situations, educational ones. Like I said, board meetings, municipality meetings, etc. Automated solutions just don't cut it and won't cut it for many, many years to come. So again, it's not about the progression of solutions. It's about whether your message matters. I think that's what you need to focus on. So can you accept omissions? Can you accept gibberish instead of the real message that you want communicated? I hope that answers your question, Stephanie.
Industry standards.
Industry standards. Yeah. There you go. There's a great note here. Thank you. I would love for our HR team to be able to view this information. Thank you, Zachary. Yes, in fact, we have a lot of interest from HR groups or professionals. And Michael, in fact, is a specialist in human resources and employment law. So we have a specialized webinar just on Title I. And that is relevant to employment and HR. So we warmly invite you and your HR team to join us. Tomorrow we'll be having that webinar at exactly the same time. If you can't find the link on our blog, which you should be able to, but if you can't find the registration link there, please just send me an email. It's up on the screen, and I will send you the link afterwards. and please join us. I think we use different case studies, much more relevant to HR, and of course we talk about a different title as well. So I think that'll be very useful to your team. So I'm just looking through here if we have missed any comments. We got a lot of thank yous, so thank you for everyone joining us. And we have some people looking forward to rewatching this webinar. So I don't see any particular questions in the waiting here, so I think that's going to be all. Just as a goodbye note here, we will be sending you all a quick survey very shortly. It'll come out automatically after the webinar. Please take a few minutes to share your thoughts to help us improve our content for future audiences. Support us, please, in generating more valuable content by liking and sharing our social media posts, connecting with us on LinkedIn and Facebook. I'm really glad you were here with us today. The reason is that by being here, you've demonstrated that ADA compliance is important to you, and that you have begun to take steps towards improving conditions for the deaf, the hard of hearing, and the blind communities. So I commend you on that. Thank you once again. Come back and join us for ADA compliance webinars in this series, and bring a friend. See you soon.